these are the steps. And you'll notice all the way down here is the letter of intent. So there's a lot of stuff to do ahead of time. I can answer any questions about this, but we don't have to go into the process. But these are the things that you should have on your checklist if you're getting ready to sell a company. You should be or helping a client sell a company that they should be addressing as the process unfolds. In due diligence, and we have a lot of slides on due diligence here, but, because it's something that I've grown up doing since my days in public accounting. I worked on, one of the very first things I ever did at Arthur Anderson Company was being taken off of, out of the tax department and thrown into an acquisition due diligence, my first year out of undergrad. And I've done many of them over my career, both as an accountant and as a lawyer. And I can remember the last one I did was, big one I did was when I was with Mintz Levin in the early 2000s, and it was literally a multi-billion-dollar acquisition that we were working on. And I was head of the due diligence team, and we had 17 lawyers from Mintz Levin. We flew down to Texas, and we were doing due diligence with the buyer. We were the seller doing due diligence with the buyer's team, and it was crazy. I mean, I didn't know a lot about this company, and I was learning about it on the fly, and I'm sort of directing everybody, go do this, go do this, go do this. And it's an interesting exercise, but the buyer really is the one who's the most concerned about everything that they're getting. So they want everything about the business that they can get before they commit to anything, which is logical. If I'm representing the buyer, I want as much information. I want all the employees' names. I want their salaries and bonuses and their comp levels. I want their tenure. I want what projects they're working on. I want to see the contracts behind the projects. I want to read those contracts, even if they're in top secret security clearance. Can't do that. You're not supposed to do that. You're not allowed to do that. But I want to see them. I want to know who the customers are, top to bottom. I want to know everything about the business. Whereas the seller, they're not so certain that this is going to work. They want to make sure that the deal is going to be structured properly. So there are ways of dribbling out information, and you can actually build this into your letter of intent that says, if you hit this milestone, buyer, in terms of, agreeing on the earnout or agreeing on this or that or the other, we'll give you this information. But usually when it comes to the customers, particularly in the government contracts world, we wait till the very end. We schedule meetings with a couple of the top customers, and we want our client, the seller, accompanying them, and we actually will script out the language that we want the buyer to use in those meetings, because we don't want them screwing it up. If the deal falls through, we don't want them screwing it up with our clients who we have to deal with moving forward. But the NDA, which I mentioned earlier, is extremely important in this context, the non-disclosure agreement. Again, buyer's perspective, he's willing to take as long as he needs. He may want to close quickly, but he's willing to take as long as he needs, but he wants total access. Quality of earnings analysis is something that they'll bring in their accounting firm to do, typically. Ernst & Young, Deloitte. I've dealt with them all on these issues. And their job is to take what the CFO of the seller has presented in terms of financial statements and backup and books and records, and poke holes in everything. And that's what they do. And the key is for the CFO not to get upset about it, CFO. And the key is for the investment banker to mollify the seller and make sure that they understand that some of the points that they're raising may be valid. But it's our job, with our information, to negotiate back against anything that they raise in the quality of earnings analysis. And invariably, good accountants will find stuff. We had a major issue in the acquisition that fell through last year that a private equity firm was conducting, and we had disclosed it up front, but then they really started to realize what the magnitude of that could be, and so we called off the transaction because they wanted to reduce the purchase price by so much that we just said, we're not going to do it, and we didn't need to do it. And we've taken action to correct the problem, moving ahead to the next transaction. Technology and diligence is absolutely critical as well. The seller really does not want to give a lot of access to the buyer. So they may name one or maybe two people who are going to handle the diligence process, and they don't want any of their other employees knowing about what's going on because they don't want to create a panic and they don't want people leaving. In the government contracts world, particularly where there's a dearth of good talent, we want to make sure that we keep them. And if there's a problem in keeping the employees, it might be exacerbated if everybody finds out that the company's for sale. And then I talked about benefits and integration plan. Often, the buyer doesn't focus on the fact that there needs to be a cultural fit and an employee fit. And the seller sometimes doesn't care either because they want to just get out of the business and sell it. But the sellers who really do care, who care about their employees, are going to take action to make sure that whatever is offered by the buyer takes care of the employees as well. So diligence impacts everything. It impacts the price, it impacts the structure of the deal, the reps and warranties in the acquisition agreement, the closing conditions, whether or not we have an escrow that we have to hold back some of the purchase price to indemnify the buyer against any breaches. The diligence has an impact on everything. And the failure to perform due diligence can be fatal to the buyer. First of all, lawyers can be sued for malpractice for not conducting due diligence. It's an implicit obligation in any merger and acquisition transaction that you tell your client that we need, as a buyer, we need to conduct extensive due diligence to make sure that there's no hidden, unwanted liabilities or contingencies in the deal. But from the seller's perspective, they need to conduct due diligence because they may not know what they don't know. So they have an obligation to conduct an inquiry. And if the buyer went ahead based on the seller's representations and didn't do their full due diligence, and then in their contract they put in one of these provisions that says, well, you promised that these reps and warranties that you made to us were going to be true and accurate, and now they're not. But the buyer didn't do due diligence. There are cases in the Second Circuit Court of Appeals and in the Fourth Circuit where we reside that says, oh, buyer, you didn't do your due diligence? Sorry, you can't hold the seller to these reps and warranties because you implicitly had knowledge and you should have gone ahead and done something about it. I'm oversimplifying the facts in a couple of major cases, but the idea is the buyer really has to do due diligence. So in due diligence, we've got a lot of considerations. I'm going to skip through some of these because I don't want to spend the whole time talking about it. But when you're doing due diligence from the outside looking in, or even from the seller's counsel's perspective, what are we looking for? We're looking for potential threats of litigation or any kind of contingencies, undisclosed liabilities, unusual patterns in expenses and revenues. Why are things going up and down so much? And we need to have answers for all of them. The CFO is going to answer all the questions on the financial side. He or she is going to have to know exactly why things are a certain way instead of just shooting from the hip and coming up with sort of an off-the-cuff answer. The better answer is, I don't know, let me investigate. Let me find out. What are the shortcomings in the contracts that we said are going to generate $50 million in revenue next year instead of the 35 that we have today? What are the restricted covenants in our deals that are going to prevent us from being acquired by the buyer? Because there may be a non-compete in some of our contracts that would prevent us from being acquired by a strategic buyer in certain cases. Is there a change in control triggered that's going to require us to get consent of our landlords or our contract partners, our subcontractors, our contractors, our government partners? Are there capital structure flaws? Example, client sold stock at different prices to different people in the same year because they needed money. And they just said, this is what we sell our stock for, but they sold it at different prices. I'm going to turn to Tim again and ask him if he has any reaction to that.
Especially at different prices, different terms, great minority shareholder issues.
You may have created an issue of the person who bought the stock having a right of rescission under certain state and federal securities law. So it's a securities law issue. So how did you sell your stock? Who did you sell it to? What were the terms? What were the terms of the agreement? oftentimes they'll just have a one-pager that says, I hereby purchase 10 shares of, whatever. And it may work, but it may not. And the reason I say it's important is because when we get to the contract, the seller has to make certain representations and warranties to the buyer that, for example, their stock is validly issued and duly authorized and non-assessable. And these are terms of law that have application in every transaction. And if you can't make those reps and warranties, you're not going to be able to sell the company. So we have to make sure that everything that's been done to issue stock or to redeem it over the years has been done right.